right, well, welcome. Thank you, everybody, for coming to another presentation on Wills and Trusts 101. Has anyone attended any of my previous Zoom seminars by chance? Oh, first time? Oh, back there? Okay, perfect. All right, so we're just going to be generally talking about the differences between wills and trusts, and I'll be doing a Q&A at the end too, so if you have any questions afterwards, I'd be happy to answer them, or if you don't feel comfortable asking in the group setting, I can always chat with you afterwards too. But before I get started, we do have the Ohana Walk that's coming up on Saturday, September 16th, so if you're not registered already, you can go to the ACC website and register. All right. Oh yeah, there's information there. Okay, ready to start? All right. Okay, so just a little bit about me. My name is Alyssa Chow. I'm an attorney in the area. I actually born and raised in Sacramento, so grew up in the Pocket area. My parents still live down the street, and you might see my mom playing pickleball around here too, or maybe at Lewis Park. So if anyone knows Sue Chow, that's my mom. Just tell her I gave her a shout out. I've been volunteering with ACC doing these types of presentations going on about, I think, 7 years now. Just, talking about estate planning or any other topics that people are interested in. So if there's anything that I don't touch on today that you're interested in related to probate or conservatorship or wills and trusts, please also let me know or let Ted know, and we can maybe put something together for another presentation in the future. Let's see. So yeah, even sort of growing up in the neighborhood, used to volunteer at the at ACC. Pre-pandemic, you probably might have seen me around too, doing some help at like crab feeds or bussing tables and things like that. So hoping to get back into that a little bit more. But for now, I'm doing these types of presentations with ACC. Okay. So really what I want to talk about today is estate planning generally. My practice does cover estate planning, probate, and conservatorship work. And so just kind of keeping in mind that whenever I'm representing clients with their estate planning, I'm also keeping sort of the practical considerations in mind and also trying to think of the best way we can streamline things for you. Now, some people are probably already doing one form of estate planning or another, and so I've got a list here on the screen, but one of them would be beneficiary designation. So a lot of people with things like your life insurance or your retirement accounts, you're probably already doing a form of estate planning by designating a beneficiary for those types of accounts so that upon your passing, you've already put instructions in place for where those assets should go. That in and of itself is a type of estate planning which can be very effective for a lot of people, but it really depends on who your intended beneficiaries are. So it can be really important to maybe double check that and just make sure that it's exactly how you want it to be set up. Another category would be taking title to property. So that can be in the form of generally real estate or possibly things like your bank accounts or investment accounts. With real property in particular, I do often see people who maybe with a partner or with a spouse, they jointly own that property. And so the way that you take title really matters as far as what happens to that property if you become incapacitated or if you ever pass away, right? So there's kind of built-in rules depending on the different ways that you take title. Couple of examples of that might be as what we call TIC or tenants in common. That's one method. Another one would be joint tenancy or JT. That's sort of like your survival of the fittest method where whoever's left on title is now the sole owner of that property. And so depending on the way that you take title, it could have either intended or unintended consequences about your interest in that property upon your passing. With things like bank accounts or other financial accounts where you might have joint ownership with someone else, another maybe intended or unintended consequence would be that if you pass away, usually the way that those types of accounts are set up, whoever the other owner is or owners are, they're the ones who are going to end up being the legal owners of whatever the remaining funds are in that account. So it's pretty common where I have clients who tell me, oh yeah, I've got my adult child's on the account with me because I want them to be able to help me pay bills, but maybe they have other children as well. If I usually will tell those clients, okay, if that's the setup that you have, just know that it is giving that one child access to the account so they can help you, but the potential downside is that legally, upon your passing, that child is now the owner of whatever that money is, and they are not legally obligated to share it with their siblings, and even if they do, there may be unintended consequences there too. So just something to keep in mind. And then another category of estate planning, which we're really going to dive into today, has to do with legal documents. So that's sort of my realm as an estate planning attorney. We'll talk about a revocable living trust as one of the more common types of trust documents. You've also got a last will and testament, a durable power of attorney for finances, and then an advanced healthcare directive. So those tend to be kind of the four big estate planning documents that you're mostly going to see in a standard estate planning portfolio. All right, so let's talk about the big one first, which is the last will and testament. I think this is the one that most people are going to be the most familiar with, and that you probably have heard about more in terms of Hollywood and just through discussions with friends and family. Usually people default to referencing a will as the type of document that they're kind of thinking that they're doing as the main estate planning. Now, a traditional standalone last will and testament, if that's the only document that you're not doing a trust, you're just doing a will, this type of document can be very effective in a couple of different ways. One big way is that it does allow you to name who should be in charge of sort of managing everything, who's in charge of paying any final bills, distributing assets, dealing with creditors, kind of all of that. So that would be your executor, and that's the term that we use for the person you name under your will. The other function of a will is going to be that it allows you to choose where you want your assets to go upon your death. So that would be identifying who your beneficiaries are, whether it's for specific assets or whether you're thinking more along the lines of, maybe shares or percentages of whatever's left among certain people. So these are kind of the main functions of your standalone last will and testament, and can be really effective as far as, making sure that you choose the right person and the person you trust to step in, and ultimately where you want assets to go. Now, the only problem with just a will, and probably the most common misconception that I see as an estate planning attorney, is that having a will is going to help you avoid probate. And we'll talk a little bit about what probate looks like too in just a second. But if somebody has just a standalone last will and testament, or if they have no estate planning documents at all, and their estate is worth over $184,500 upon their death, then the probate court is going to be the only entity with the authority to oversee the administration of that will. So it's a very specific number, and that number has changed over time. April of 2022, that number was $166,250, which don't ask me why the legislature decided that these were the numbers that they wanted to go with. But even that number will probably fluctuate over time with this new $184,500 value. Another thing to keep in mind is that the term estate is a relatively technical term when it comes to probate. So earlier, when we were talking about different types of estate planning, I was talking about beneficiary designations or maybe joint ownership. So depending on the way that you might already have some of your assets set up, they may or may not fall under the category of an estate that would apply to a will. So kind of a good rule of thumb when you're looking at whether a will is going to push you into probate is if the value of your assets that you leave just in your name, so something that you don't own jointly with someone else, or that you don't have a beneficiary for, or that you don't have connected to a legal document like a trust, The combined value of those assets then that are left just in your name would push you into probate if it's over 184,500. Okay. And so I guess the next question, of course, is, well, what's the big deal with probate? So anybody who's in the audience today, has anyone had to deal with probate before? Or known somebody who's had to deal with probate, maybe? Okay. So it's not the most efficient process, and it's not the cheapest process. 3 big downsides to dealing with the probate court are going to be: 1, it's quite lengthy; 2, it's quite expensive; and 3, it's a very public process. So if you're going to end up in the probate court for an administration, at least in Sacramento County, you're looking at probably about a year to a year and a half, and that's assuming no one's fighting and no strange issues pop up. So about a year to a year and a half before that probate is completed. And to give you an idea, most of the time with this particular court in Sacramento, you're looking at waiting about 5 months just to get a hearing date, to get the process either started or closed up. So just something to keep in mind timing-wise. It's also quite expensive, so I don't really want to get too much in the weeds as far as calculations go, but for an example, just one estate where there's one piece of property that's worth maybe $300,000, the way that the court will calculate the attorney's fees and the executor's fees will put that estate at about $9,000 for attorney's fees, about $9,000 for executor's fees, and somewhere in the ballpark of $1,500 to $2,000 in just court fees. So for that one piece of property to go through probate, if somebody only had a will or they had no estate planning documents at all and that property ended up just in their name upon their death, then it's about 20 grand to get through probate. So quite expensive. And then lastly, it is a public process. So I don't know if anyone is interested in courtroom drama, but probate court, or really any courts in general in California, most of them have a Zoom link. So if you're interested in just tuning in for anyone's hearing, you can tune right in and see what's going on. So you get to know who's in charge, what the issues are. Even all of the documents themselves end up being discoverable online for the most part. So, you know, if you don't necessarily want all of your heirs' names and addresses and asset information related to the probate to be openly and publicly available, you probably want to avoid the probate court because pretty much anybody can download or purchase that information. All right. So what's a better alternative? So if it looks like the value of your estate is going to be over that $184,500 value, then a revocable living trust is probably going to be the primary document that you're going to want to rely on. When it comes to a revocable living trust, it's kind of this funny idea, right? You're thinking, okay, what actually is this? What am I doing? How is it actually working for me? And at its core, a revocable living trust is really just a legal contract. So you're putting together all of the terms legally for basically what you want as far as who's in charge and where assets go. So not very much unlike a will, but the primary difference between the two is that with the trust, it's going to be effective right when you sign it. So it's a living document. It's something that you can adjust during lifetime, so it's amendable as many times as you want to. If you're an individual person who's doing a trust, you can update the trustees, you can update the beneficiaries, you can update any of the real structural terms of your own trust as many times as you want to. If it's a joint trust where it's for you and a spouse or you and a partner, then you would both need to sign off generally on all of those changes. But yeah, it's pretty flexible as far as contracting goes. And really I would say functionally, what makes a trust more effective at management and transfer of assets is that it really just serves as kind of like a legal key. So you would come up with a name for your trust. That's like the identifier for this contract, right, that you've put together. And you want to link all of your assets, or as many of your assets as possible, to this name that you've come up with for your trust. And then that grants access, or it's like a legal key to accessing those assets to whoever it is that you've left in charge. Your successor trustee, rather than executor then, is going to be the person who can step in for you either during lifetime if you need their help because you've become incapacitated, or post-death if you've been totally fine your whole life and then you pass and then you need them to step in, right? So generally speaking, with a revocable living trust, that's going to allow you, assuming assets are properly funded into your trust, that's going to allow you to avoid any sort of court oversight for the administration of your affairs. Okay, so how does the trust really work? I've alluded to it already, but really you want to make sure that you're properly funding your assets into your trust. So a couple different categories of assets that would be considered properly funded into one's trust. One category would be assets that are actually titled in the name of that living trust. So if I come up with the Alyssa Chow Living Trust, I want to make sure that things like my home, my bank accounts, my investment accounts, that those are all titled in the name of my trust. The way that we would go about doing that with real property is through a transfer deed. So part of my job as an attorney then is to basically draft a grant deed or a quitclaim deed, transferring ownership out of the name of the owner individually and into the name of the trust. So from Alyssa Chow to the Alyssa Chow Living Trust. Moving forward with that piece of real estate, it looks like my trust owns it. So if anything happens to me and something needed to be done with that property, let's say it needed to be refinanced or it needed to be sold, if I'm incapacitated, then my trust has already designated who can step in and manage any trust assets on my behalf. And that trustee can step in, talk to a title company, talk to a mortgage company, and they don't need to go to court to ask for permission to do that because I've already given them that authority through the trust. That would be an example of a funded asset for titling purposes, right, with real estate. Same thing with like your bank accounts or investment accounts. You could go to the financial institutions and you could convert your existing accounts so that the title shows the name of your trust. There's sort of a couple different schools of thought on how to handle financial accounts because technically you could also do beneficiary designations if you want to. So part of my job as an attorney is to just kind of go through the different assets with clients and figure out what makes the most sense. Do we want to convert the accounts or do we want to do beneficiary designations, right? And then so that second category would then be assets that possibly designate the trust as a beneficiary, or you may designate other people as beneficiaries. So it kind of just depends on what your overall goals are. But the only things that are actually going to be controlled by the terms of your trust will either be assets that are titled in the name of that trust upon your death, or assets that have the trust as the beneficiary of those assets. Most commonly, I'll have clients with life insurance policies who might want to designate their trust as the beneficiary of those life insurance policies so that upon their death, their trustee makes a claim with, let's say, New York Life or Principal or whatever the company might be. And then that means from there on, the trust can deposit the funds into a trust account and then use those funds to pay any bills, deal with taxes, and then ultimately distribute out to the beneficiaries. Just keep in mind that assets that have beneficiaries other than the trust, though, are going to pass directly to those beneficiaries. So, for example, if you set up a trust, just because you've set that trust up, it doesn't mean that automatically all of your assets are going to flow through that trust, right? If you set up a retirement account years ago and you've got your sibling as the beneficiary on there, or you've got a niece or a nephew, or only one child and you've got multiple children, however you had that set up before, that's still in place. So you do have to take that extra step after you've created your trust to go to the financial institution and complete the paperwork to update that beneficiary designation. Because otherwise, your life insurance, your retirement, they don't know that a trust exists. You got to tell them, right? So if you do want the trust instructions to control, you've got to do a little homework after the trust has been established. Okay. All right, so really kind of the main topic for today is will versus a trust, right? So really, what's the difference? Why would you need one versus the other? And what's probably going to make the most sense for you? With a will, that's really only going to be effective for you upon death. So it's what we call a testamentary document, which is why it's called a last will and testament. And so it's not really doing anything for you during lifetime. It still serves the purpose of identifying who's in charge and where assets go, but it likely will require probate if you're over that $184,500 value, and you're dealing with a public forum, right? So that's a will. So for people who maybe don't have any real estate, or who have real estate but it's owned as joint tenants, and they don't care if they're the first to die that the other joint tenant would then own the entire property, okay, then maybe a will might work for that scenario. So it's kind of on a case-by-case basis for whether just a will is going to be appropriate for you, right? Versus a trust, that's going to be another document that's going to be more appropriate for people who are looking for a document that's effective for them during lifetime and upon their death for the ultimate management and distribution of assets. And hoping that you funded the trust appropriately, it shouldn't require probate. So there's no default necessarily where the probate court has to get involved when it comes to a trust administration, okay? The other benefit of doing a trust is that it is a privately administered document. So one of the biggest questions I think that I get from a lot of clients once we're signing their documents, where, you know, I make them go through the whole process, we're notarizing, we're making sure everything is done. I give them their binder and they go, great, what do I do with this, right? Where does it go? Who gets this? Do I send it somewhere? Do I give copies to people? And I tell them it's entirely up to you. You could keep it a complete secret and have nobody know about it until maybe you've got a letter that you give to someone and say, open this upon my death, and that gives you a map to where I've kept my trust. But you know, it truly is entirely up to you when it comes to your trust and who ultimately gets to see it, as long as you're living, right? So you could disclose that trust to your successor trustee. I do recommend it so that they're not surprised when it comes time for them to step in and actually start helping you. But for the most part, I tell people just keep your binder or your documents in a safe place, and generally let your successors know where you're keeping it. There are some ways to do some sort of like reverse treasure hunting whenever you think that someone might have a trust but you're not really sure where they've kept it. It's not uncommon that I have people come to me later and they say, I'm pretty sure my aunt had a trust, or I'm pretty sure my parents had a trust, but we can't find it anywhere. One good way to go back and double check on that is if they had real estate at any time. Usually the attorneys, like myself, who would be drafting those types of documents for them, we put our information up at the top, and really the only document out of everything in a trust package that becomes public is going to be that deed that transfers ownership into the name of the trust. So one way that I try to help people locate the documents, because it's sort of a double-edged sword, right, with it being private, one way that I'll help people locate them later is by doing a title search and seeing, okay, who was the attorney who drafted the documents, and fingers crossed, they have a copy of the documents as well. So I don't know if anyone's had to deal with that before, but it is very much a double-edged sword when it comes to the privately administered document that is a trust, because sometimes you can't find it. So just a couple of practice tips would be, go ahead and just maybe let your successor know where you're keeping it. All right. A couple of other documents that are supporting documents and that are effective only during lifetime for you would be your powers of attorney. So in California, we break those up into two categories. You've got your durable power of attorney for financial matters, and then you've got your advanced healthcare directive, and we'll talk about that one in just a second. But for the durable power of attorney for financial matters, that's going to let you appoint an agent or kind of like a proxy to act on your behalf during lifetime regarding finances. So if you think about things like filing your taxes or dealing with insurance or your credit card bills or kind of your day-to-day financial affairs, Those are things that you're managing on your own. But if you become incapacitated, even if it's temporarily or permanently, then you're going to want to have somebody who has the authority to then be able to step into your shoes and act as if they are you. Now, the reason why that power goes away when you pass away is because they can't act like they're you anymore, right, if you're gone. So it's a document that's super handy during lifetime, but just keep in mind that once you've passed, that authority goes away. I sometimes have people come to me and say, well, I was the power of attorney, so, but I'm not getting any access to anything anymore because the person has passed away. And unfortunately, that's just sort of the nature of that type of document. Really handy during lifetime, but doesn't do anything for you post-death. Okay. All right, and then you've also got your Advanced Healthcare Directive. So with your Advanced Healthcare Directive, kind of the same idea as with the Durable Power of Attorney for finances, but just specifically related to medical. This is going to let you choose an agent or a proxy to make medical decisions for you during lifetime. So that'll be things like making appointments with your doctor, making treatment decisions, checking you in and out of facilities if needed. And you, of course, as long as you're able to give informed consent for your treatment or withholding of treatment, your healthcare provider should be listening to you first and foremost, right? It's really just your agents step in if you can't make those decisions on your own anymore. And part of the benefit of doing an Advanced Healthcare Directive is you do get to identify sort of what your preferences are. So there's some categories like end of life preferences, like choice to prolong life, choice not to prolong life, or if those two very general categories don't quite fit what you're looking for, then you can specify a little bit more, what you would want or what you wouldn't want. One thing I do want to point out, though, is that an Advanced Healthcare Directive is going to be different than a POLST form. So if anyone's familiar with that, that's a POLST. That stands for Physician's Orders for Life-Sustaining Treatment. You generally have to do that document with your healthcare provider. So they're the only ones who can do that for you. It's that like bright pink, sort of thicker piece of paper that you might put on your refrigerator or on the wall near your door, just in case emergency personnel do come to your home at some point. If you fall or there's a medical event, that document more specifically will talk about resuscitation and certain types of emergency treatment that may or may not be accepted by you, right? So Advanced Healthcare Directive really is more so along the lines of identifying just a proxy or an agent for you if you do need help during lifetime with medical. Okay. So generally, benefits of estate planning in general, as it relates to a revocable living trust and kind of the four main documents that we've talked about. There's ease of administration for your affairs according to your wishes. Hopefully you can avoid the probate court, assuming that you've funded that trust properly. And for the most part, you get some privacy and some efficiency with the way that things are handled. I think one document that I slightly skipped over in the context of a revocable living trust is that you would get a will, but it's a funny kind of will. We call it a pour-over will. Anyone familiar with a pour-over will? Yeah, it's P-O-U-R, pour-over, and it serves a super, super narrow purpose, which is all it does is serves as a backup to the trust. So if somebody is doing a trust as their primary estate planning document, we sort of treat that as like the star of the show, right? We're relying on the trust. We're hoping that that's the main document that helps you avoid probate court, makes it real easy to administer all of your affairs. But just in case you've got like a wayward Golden One account out there that you opened 30 years ago and you totally forgot about it when you were doing your trust, then the pour-over will allow whoever's in charge of your trust or whoever you've identified who could step in, they essentially can scoop it up and pour it over into the trust. So you're basically just using that very narrowly purposed pour-over will to redirect assets into the trust, because the trust is going to have all of the instructions for sort of how everything should work, right? So sorry, I skipped over that one earlier. All right. So again, who needs estate planning? At a minimum, I would say any adult 18 and up should at least have a durable power of attorney for finances and an advanced healthcare directive. It's not uncommon that I'll work with my clients who have kids who, are going off to college, and we just set up powers of attorney for them in case there's an accident or something happens. Once you're legally an adult, you have all of your own financial and medical decisions. So unless you've identified who can help step in and make those decisions for you, someone's going to have to go to court to ask for permission to help you if you don't have those documents. All right, so really keeping in mind that not just the trust and the will, of course, that would be really helpful with possible asset management, but just on the day-to-day, making sure that you're okay, right, that you're supported. Powers of attorney can be really helpful. And then generally speaking, a living trust is going to be the most appropriate for if you've got minor beneficiaries. So in California, anyone under the age of 18 can't be designated as a direct beneficiary on life insurance or retirement, and you generally don't want them to get any gifts outright. So a trust would allow you and give you that flexibility to put some guidelines on how and when they should get their share, especially if you're not too keen on maybe like a 16-year-old getting a bunch of money all at once. You could put some restrictions on, okay, maybe they need to be at least a certain age and complete a certain number of tasks or something like that, right, before they could get it. But a trust is going to be really good for controlling those types of variables for your beneficiaries. It can also be really good for beneficiaries who just aren't good at managing money. Maybe they've got a lot of creditors out there. Maybe you're worried that they'll just spend it all at once. And so with a trust, something that I do often with clients is we'll set it up so that there's more of a staggered distribution, right? So you maybe give a little bit 1 year, a little bit a few years later, and then try to spread it out a little bit. And then, of course, we talked about earlier, any estates that are over that $184,500 value, and if there's any real estate, definitely, then you'll want to consider doing a trust, right? So these are going to be some general categories for why a trust might be appropriate versus just doing a will. Okay. All right. And that is it for today. And that's all of it. Yeah, thank you. I know it's a lot of information all at once, and it's sort of a broad overview of the documents. Of course, with legal contracts and with a trust, you can always dive in a little bit more specifically and really put together super specific instructions if you have particular goals in mind, or it can be more general depending on how particular you want to be with those instructions. So. Did anyone have any questions that they wanted me to address? Yes.
On the asset itself, you can be owning properties, not just your own home and stuff, and then you sell them. How do you designate, or how should you handle your trust that it is in? Because I was told that you don't have to worry because it's sold already.
Oh, so if you set up a trust and you put a property into that trust and then you sell that property later? Yeah, so that's a really good question. So as far as the funding of the trust goes, you as the creator of the trust, you can always take assets out or put new assets into the trust. So you're exactly right in that if you sell a property or you close an account that was previously in your trust, it's just not controlled by the trust anymore, and you don't have to necessarily make any updates to the trust to reflect that, because later when your trustee tries to do something with that property, they won't be able to since the trust doesn't own it anymore. The only time that you might want to update your trust if it's a particular item that you've sold is if you've designated that specific item to a certain person in the trust. So for example, if you said, I've got 3 properties and I want this property to go to this person, this property to go to this person, and this property to go to this person. If you sell one of those 3 properties, that person who you've designated that particular property is out of luck, right? They're not getting anything. So if you want to give them something else in lieu of that property, you probably want to amend the trust to reflect that. But otherwise, if you didn't have a specific designation, then you really don't have to do anything to the trust at that point. Yeah. Yeah.
There's a couple questions online.
Oh, okay.
Okay, one of them is, what is the cost to do a revocable living trust and cost to do future revisions?
Oh, okay. Yeah, so generally, so I'll talk maybe generally and then also for my practice. Generally, attorneys will charge a flat rate to do a trust, and that's going to be dependent on whether you're doing an individual trust for just yourself, or whether you're doing what we would refer to as like a joint trust for yourself and a spouse, or yourself and a partner. So usually in the Sacramento area, depending on the experience of the attorney, you can probably expect to pay like $1,500 to $2,500 for an individual trust package with the trust, will, powers of attorney, right? All of that. For a joint trust, you're probably somewhere in the ballpark of like, I don't know, maybe $2,000 to $3,500, depending on the complexity. But if you're a super high net worth, meaning if you're kind of in the ballpark of like, 10 million or up in assets, then you probably, I know, a good problem to have, but you're probably going to end up spending more money on more particularly targeted tax planning as well, right? So that's going to be your general sort of range. The way that I charge for my estate plans is for an individual person with just, let's say, one piece of real estate, it's $1,900 to do the trust package. For a joint trust for married couple or partners or spouses, that would be $2,900 for just the primary residence. If there's any additional real estate, then depending on the amount of real estate, it goes up a little bit because you have to do more property searches and transfer deeds. But that's my base for new estate plans for people. Oh, lots of questions now. Oh, and then sorry, just the follow-up to that real quick is any updates later are generally going to be at an hourly rate. So most attorneys who are looking to do amendments or updating powers of attorney are probably going to do it at whatever their hourly rate is. Mine is $3.50 an hour. Okay. Oh. I've got here, here, and here. Maybe Jean?
You talked about more complex estates. Do you have CPAs and financial planners that you normally work with?
Yeah, so there's a few financial advisors in the area who, I've got a handful kind of depending on what the clients are looking for. So depending on the location, the types of investments that they're looking to do, and the amount of tax advice they're looking for. But yeah, generally I do work with professional partners. And if clients already have a CPA or a financial advisor that they're already working with, then I'm always happy to work directly with those CPAs or financial advisors too, because then usually it ends up minimizing the amount of work the client has to do because I'll just work directly with them. Yeah. Oh, gentleman in the front.
What's a typical payment for the trustee and the attorney? They're separate fees, right?
Yes, so also a good question. So meaning once the trustee steps in later for you.
Yeah.
So California, we've got a default, which is reasonable compensation, which is a kind of a mushy legal term. But basically that means that whoever your trustee is, they keep track of their time, kind of like a timesheet, and then they bill the trust for the amount of time that they've spent. Funny enough, they also get to come up with their own hourly rate, which generally is dependent on the amount of experience that they've had. So if they've never been a trustee before, they probably can't justify charging $100 an hour for their time. But if they have before, then they can talk with their attorney about what a reasonable rate might be.
I thought at one point it was 4%.
Oh, so that would apply to a probate administration. So in probate court, if you end up having to go through a full probate, it's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and then it keeps kind of going from there in these like really funky percentage schedules. But that's just if the probate court gets involved. If it's a trust administration, then it's sort of like the wild, wild west with if you do reasonable compensation. Although I have seen sometimes people will do like 0.5% of the total value of the trust. That's what the trustee can receive. So yeah, it kind of just depends on how the trust has been set up for the trustees. And then the attorneys, it just depends on how much work the attorney is doing for the trustee. So the way that I generally do it is I give like an action items list to the trustee, and I let them pick and choose what things they feel comfortable doing on their own and what they want me to help them with. And so, if they want the full suite, then it's probably going to, be a few $1,000s to get through the full administration. But if they only want, as needed help here and there, or maybe a document here or a document there, it could be much cheaper. So, but usually attorneys will charge hourly for their time for that. Yeah. Yes. Up at the front.
Thank you. When you move your funds in a bank account to title it to the trust, do you actually have to close those accounts and then reopen them?
Yeah, so that's a really good question too. It depends on the bank. And so part of the discussion that I usually have with clients is we try to identify which of their accounts they have the most automatic payments or direct deposits set up for. And if they've got like a Golden One account or a Chase account where, that's where the bulk of the action happens, we probably don't want to send them in there to get it converted, because the banker they work with may or may not tell them they need to close it and reopen it. So instead, what I might recommend to the client is to designate the trust as the pay on death beneficiary, or the TOD, transfer on death beneficiary. So that's a good alternative to still linking that account to the trust so that it doesn't have to go through probate, but then also letting you keep that account number intact. It's sort of funny because over time, some banks have started different policies, internal policies, for whether they'll make you close accounts or not, but then it entirely depends too on the banker that you're working with on that day. So I may give clients alternate instructions for how to handle it. Yeah. Oh. Oh, maybe just a follow-up real quick on that same topic.
It wasn't a follow-up, it's kind of a different question. How are the actual trust? Is it recorded with the county, or?
Nope, it's just private.
Totally private.
Totally private.
The name and everything is private.
Well, the name, if you've got real estate and you're transferring the ownership into your trust, the name will become publicly available because you have to record the deed. But you don't record the trust with the county recorder. You don't record it with the court because you're hoping the court doesn't have to get involved. So yeah, it truly is a private document.
Thank you.
You're welcome.
Okay, so as you age as an attorney and you
Yeah.
open up all our trusts and everything, who is your successor, or what happens? Because like I have trusts
Yeah.
opened back in 1995 when I was really young, 30-something years ago.
Yeah.
So how do I know if you're still around, or who do I contact?
So the funny thing about trusts is that it's quite transactional. We consider trust work transactional work in the legal field because the moment that you complete your trust, that trust belongs to you, meaning that you get to take it back to the attorney who helped you, or you could take it to any other attorney regardless of whether the attorney who helped you is still in practice. So most solo practitioners like myself will have a successor that's in place in case something happens to me, or if I ever were to retire in the future, I would send a notice out to all my clients letting them know, okay, I'm getting out of the business of law for one reason or another, and here's a recommendation for either my successor or maybe another person that they could meet with. But ultimately the client or whoever the documents belong to, they could decide to go anywhere that they want. For future assistance. And really any estate planning attorney should be able to take a look at your documents, whether they helped you or not, and they should be able to pick it up and help you make updates.
And all the amendables that you had over the years, where you're amending and everything.
Yeah.
I heard from somebody that they said that they have to go back to all your documents. And if you only have like the most updated one, you don't have your old ones, they have a question with that.
Yeah,
They
yeah.
they really get, kind of like, so, well, when you bring us your old one, which you don't have any idea where it is.
Yeah.
So how do you proceed from there?
If documents, well, so it depends on if somebody's coming to me and they tell me, I did my documents 30 years ago, I can't find the original trust or even a copy of the trust, and I've got maybe an amendment done 10 years ago, but that's it. Usually the course of action for something like that would be what we call a restated amendment, which means that as long as you've got the name of your trust, and if it was an individual trust you did for yourself, then we most likely could just come up with a fresh new set of instructions, but use that same title so that you don't have to then retitle everything all over again into a new trust. So you still get to keep, whatever the name was with that original date of execution, but you're doing brand new current instructions for that. So basically a new trust document. That would be the way I would handle that. Yeah, so it just depends. Yeah.
It's necessary.
Litigate on behalf of your clients, or do you have a partner who does that?
So I personally don't handle contested or litigated matters, but I have a really great network of colleagues who do. So depending on the county and the particular issue, usually I'll do an introduction to that attorney and the client so that they can pick up the issue together. And usually what I'll do too is just provide support in the background free of charge if that attorney who we've transferred the case to, if they have questions about how things were set up or some of maybe the dynamics of the parties or things like that, I'm happy to be a resource for that transition. Yeah.
I know there's 2 more questions online.
Oh, okay.
One of them is, could you just go over more what a pour-over will is?
Oh, okay. So yeah, the pour-over will would be just that supporting document if you did a revocable living trust. And if you've ever seen a pour-over will, it's pretty bare bones. It will say probably at the top, last will and testament. We sort of colloquially refer to it as a pour-over will because of the scooping and the pouring into the trust. But it still is technically a last will and testament, and all it's going to do really is mirror back to the trust. So you'll see the name of the trust referenced in that pour-over will. You'll probably see some information about who the family members are, like if the person is married or if they have children or anything like that. So, but otherwise, the function of the pour-over will really is just to be a backup to the trust, so that if you do forget to put something in the trust and it falls into that estate category where it's not jointly owned, there's no beneficiary designated, it's just kind of floating out there in your name individually, then the pour-over will redirect it into your trust.
Okay, and the next question is, what type of document would be appropriate for funeral and burial instructions? The example they gave was what to do with a person's ashes.
Yes, so a supplemental document that I usually will prepare for people if they want it would be what I refer to as a final disposition instructions document, and that would specify exactly that, whether you prefer cremation, whether you prefer burial, and if you've already prepaid for services, like if you've got a plot at East Lawn or any of the other locations in whether it's in town or not, right? We can specify the place where you've made those pre-need arrangements, along with usually the contract number and the plot number or the niche number, whatever it might be. That way, your whoever steps in later, they're not double paying for something or paying for a different location when you've already paid for a spot.
What did you call that?
I just refer to it as a final disposition instructions, but you might see it as like memorial instructions or post-death instructions. I like to do it just as a supplemental document if clients want me to. And it's not an extra charge. Yeah.
Does every beneficiary get a copy, automatically get a copy of the will? I mean, the trust?
Of the trust. Yes. So once you pass away, there's 2 categories of people who are entitled to a copy of the trust itself. It's going to be what are referred to as your heirs at law, meaning Like if you've got children, then all of your children are entitled to a copy of that trust, right? So it'd be heirs at law, and then the other category is beneficiaries. So whoever you've specifically named to receive assets in the trust, they're going to need to know that they should expect something. So yeah, those are the two categories.
Going back to the final disposition that you were saying.
Yeah.
What if the mom or something passes on, but she had already created where her burial would be and everything?
Uh-huh.
But during her, I guess, last few years, she turned on a power of attorney to a niece or a nephew.
Okay.
And so now the daughter is complaining and saying, okay, let's use where mom already designated and paid for.
Mm-hmm.
But they said, no, sorry, whoever had the power of attorney has the right to do. So she ended up just cremating and leaving the urn at home. According to the Catholic, I guess, dying, as they prefer you to be at a designated crypt or whatever burial site.
So for an advanced healthcare directive, that's the only document that has a super narrow, also narrow exception to how effective it is after you've passed away. With your advanced healthcare directive, whoever you've chosen as your agent or your proxy naturally also has that post-death authorization. So even if you put together your final disposition instructions, it's possible that the agent overrides those wishes and just does what they want to do and goes rogue. At that point, it's just a matter of whether family wants to litigate the issue and kind of what the damages would be for something like that. But it is possible for that agent to just authorize cremation even if the instructions had said burial or vice versa, right? That doesn't happen too often, but it sounds, I mean, I don't know if it sounds like a kind of a specific example, but if it's not, yeah. I'm sorry that happened though. That's, yeah. But yeah, it doesn't happen super often, but I have heard it happen before. Yeah. All right.
Thank you.
Yeah, of course. Well, yeah, thank you everybody for coming. I do offer free consultations for anyone who comes to these presentations too, so I'll put a sign-up sheet out and I'll put some of my cards out as well. And then if you want, just feel free to email me any other questions too. Phone, yeah. Yeah, you can always call. My receptionist can get you scheduled with a consultation. Yeah. All right. Okay, thank you.